If you don't plan, you're stupid.
Welcome to If You Don't Plan, You're Stupid with estate planning attorney Andrew Rosenberg. Andy helps Florida families create estate plans that actually work. My name is John Clemens. Today we're diving into a topic that hits home for a lot of people, and that's estate planning for unmarried couples. So Andy, before we dig in, I just want to say it's always so fun to talk to you. Thanks for coming on, man.
John, it's always good to talk to you. I feel like I just saw you, though. But
I feel like that same way, yeah.
Let's do it, my friend. Let's get into this.
Let's dig into this. So this is a common thing, much more common now than it used to be, 50, 60, 100 years ago.
Why is that, couples, by the way?
I don't know, man. I'm happily married for about 20 years, so I'm on the marriage train.
I'm 32 plus years in to my one and only love of my life, but I don't understand why these generations below me or next generations, etc., they're not getting married.
Yeah, I don't know, but I'm not here to judge.
Maybe they're smarter than we are.
Maybe so. Right? I don't know. Maybe so. But let's dig into it because there's a lot of people in this situation, and they still need legal advice too. So let's talk about that. All right. You're based in Florida. We're going to make this Florida centric. So under Florida law, if someone passes away without a will and they're not married, but they have a long-term partner, like what happens? What happens to the estate? What happens to the all the resources?
I'm going to give you two words. You're screwed.
I had a feeling that was coming, yeah.
Yeah, that's basically it. So, and the only reason I remember this is because it happened the year I was born. So I remember that date. In January of 1968. So now you know, guys, I am officially 57 years old, almost 58. So in 1968, they got rid in Florida of common law marriage. So after 1968, if you live together from 1969 to today and one of you passes away, the other person has zero rights. And then there's silence. Yeah. It's crazy. It's crazy. People don't realize that. They think that the world's changed and that the laws should change with it. But unfortunately, in the state of Florida, if you are living with somebody, I don't care if it's two guys living together, two girls, or a male, female, doesn't matter. You have no rights when it comes to the other person if something were to happen. And that's why we're going to talk about this and the ramifications of this today on the episode.
Yeah. And I asked you last episode about, kind of the reasoning behind some of these Florida laws. Do you happen to know why that common law marriage was kind of, taken off of the books, so to speak?
I don't know. I would imagine that there was a strong lobby by someone that basically said, this is not fair. We never officially tied the knot. Why should I be penalized with alimony and all sorts of other problems if we didn't get married? Or why should she have rights when I pass away, or he have rights, etc.? So I imagine there's some sort of a lobby that got involved and said, we want to get rid of this thing. But I don't know the actual history of why they did get rid of common law marriage.
Yeah. You do raise an interesting point, though, in that, we're talking about maybe some of the benefits of marriage, but there are also potential drawbacks, like you said, alimony or other issues. So I could see it might be like, well, there's some pros and cons of that I maybe hadn't thought of before.
Yeah, listen, just like anything you look at, there's pros and cons. So yeah, there are pros and cons to marriage. The pros are obviously you have a spouse for hopefully the rest of your life, and you have rights to things, when things happen. The cons are if you get divorced, now we got to deal with alimony and division of assets and all these other things. Although I will tell you the law changed recently. I'm not a family law attorney, but very recently, within the past 2 years, I think, they got rid of lifetime alimony in the state of Florida. So now, if you get divorced, it's not lifetime anymore, which is, I think, a bad thing, but that's just my personal opinion. But yeah, so there's obviously pros and cons to marriage. I don't know if there's pros and cons to living together. I guess maybe a pro is you guys fight and you're like, can't stand each other. You just say, okay, I'm done. And you pick up your things and you go your separate ways, and there's no legal rights to anything. at that point. Maybe that's a pro, maybe that's a con at the same time. I don't know. But there's a lot more, in my opinion, there's a lot more cons to not getting married and living together than there are pros. And that's what we're going to talk about. As far as the legal side of the equation.
Legally speaking, yes. Yeah. Again, not trying to pass moral judgment. We're just talking about the law.
Yeah, I'm not. Yeah, no moral judgment. I mean, you could do. Listen, my daughter's living with a boyfriend right now, so I mean, I'm fine with that. But yeah, no more. I have no moral judgment here. I'm talking about the legal side of the cons.
Yeah, exactly. And so I want to talk about that a little bit more because we mentioned if you're living together, not married, one spouse dies, for example, there's basically you have no legal rights at that point. So what about things like wills or assigning powers of attorney or healthcare surrogate forms? Can those give that surviving, I guess not spouse, but partner, some of those legal rights back?
Yes. And that's the key. And that's what you need to understand when it comes to living together or having a partner, etc. You need to legally prepare things to protect everybody. And that's really the key to this. So here's a question. The question is obviously what you just said. If I'm living with another man and I happen to be, a gay person, which I could care less, or two women or a husband, I don't care. You're living with somebody and one of them passes away and you had a will in place and the will says everything goes to my partner or my companion. That is completely legal in the state of Florida. Absolutely perfect. And in fact, that's what you should do. Okay. So you definitely, if something happens to you, you want to make sure that you leave stuff for your significant other if you're not married, if that's what your plan is. And the one way of doing that is with a will. Okay. The other way is with titling of assets. So depending on how you title the assets, obviously there are rights as well. So let's say that my significant other don't want to get married, but we want to go buy a house, and we go buy a house and we buy it as joint tenants with rights of survivorship. Well, by law, that means if one of us passes away, the other one automatically gets it, even though we're not married. So that's another way where it protects you if you're living together and you title things jointly. Again, you can open up a brokerage account with your significant other, right? At E-Trade or Fidelity or wherever you want to do it. You can open up a joint account with my significant other and put money in that account. And then both of you have access. And if something happens, the other one has access to it, which is perfectly fine. If you don't do that, then that's what the wills are for, right? Or trust to avoid probate. Obviously, will goes through probate. So the answer is yes, for inheritance reasons. If you don't do anything, if you didn't do a will and everything was in your name and you wanted everything to go to your significant other, now we're dealing with the Florida intestate laws. If you remember, we talked about that. If you died with a will, it's testate. If you die without a will, it's called intestate. And then that means that the statute for the state of Florida, there's a Florida intestate statute. The Florida statute will determine who gets what when you pass away because you didn't have a will. And in that situation, I promise you, your significant other will have zero rights. There is nothing in the Florida statute for intestate that gives anything to your significant other. It always goes to family members. So that's where I see a lot of problems, by the way, John. I'll have someone come in after the fact. It might be a husband, not a husband, wife, but two gentlemen that lived together for 20 years. One of them passes away, and then the survivor comes to meet with me, says, "What are my rights?" And then I have to tell him, none. There's no rights because the family comes in and says, "That's our house. You're getting kicked out." And guess what? That person's getting kicked out. Not like the homestead situation that we talked about in prior episodes, John. Remember how you can't kick someone out, the spouse out? Well, they're not married. And if they're not married and you don't own it, you get kicked out. And there's nothing you could do about it. So it's a problem. It's another problem, and you mention it, with like healthcare decisions and financial decisions. So what happens if you don't pass away, right? What happens if you become disabled or incapacitated? Who can handle the significant other's financial affairs? If you don't have anything in place, you have no rights. So what do? That's why you need to have the legal documents. You need to have a durable power of attorney in place to help with the financial affairs. You need to have a healthcare surrogate in place to help with healthcare decision making. Because if you don't, and I see this all the time, you have the family on one side, someone's, God forbid, is on life support, okay, or unconscious, and doctors need to make decisions, and the boyfriend is at the hospital, and then we got the parents of the person injured at the hospital, and the parents say, we want this done, and the boyfriend says, that's not what your son wanted. Your son wanted this done instead. Guess who's going to win? The parents.
Yeah, the parents, yeah.
Without the proper documentation. It's sad. It's very sad, but it's the reality. I would say that the laws have not moved with the times. How's that?
Yeah. I think that's a pretty good summation of what we've been talking about.
Yeah. And this is really common stuff, John. Think about how many people, boyfriend, girlfriend, boyfriend, live together. And they don't even think about it. They just assume that we can do things.
Yeah. And what are some other mistakes you've seen unmarried couples make? Because again, they just assume that they had these rights.
Obviously, the first one is not putting together legal documents. That is the number one mistake by far. That is it. You need to do a will or a trust. You need to do durable powers, healthcare surrogates, living wills, HIPAA documents. All these kinds of things need to be done. That is the number one mistake. Number two mistake, we talked about it earlier on this podcast. The number two mistake is not having titling of assets correct. So not putting someone's name on an asset together with you could be a mistake. Listen, there's pros and cons to doing that, okay? So let's say that you and I are dating, John, okay, and we're living together, and we decide to open up a bank account, and we put $25,000 each in the bank account, so there's $50,000 in there for us to be able to deal with everything, okay? And then you get sued. Guess what? That entire $50,000 is now part of that lawsuit. So that's the cons of adding someone to titling of an asset, but it's important. So number one mistake, not having any documentation at all, legal documentation. Number two, not titling assets properly to make sure that you take care of it. And the third biggest mistake, you want to try and guess, John? You want to guess or no?
I have no idea.
Not putting them on as beneficiaries to life insurance and other assets.
Oh, I wouldn't have even thought about that.
Yeah, that's a big mistake. So, one of the things that I like to do with my clients on a yearly basis is get together with them and just review what's going on with everything. And so one of the things we look at is making sure the beneficiary forms are properly named and designated. And a lot of times when you're dating someone and living with someone and have a significant other and never get married, that's a problem because you forget about that beneficiary designation. And if you named your kids 20 years ago as the beneficiary and didn't change it, the kids are going to get it if you pass away, not your significant other.
Yeah. And I wanted to ask you about that as well, because as we're talking about this, I'm thinking, couples don't always stay together forever. Couples split up. So if I've gone to the legal trouble, I guess, of documenting my relationship with my person I live with is not my spouse, we decide to go our separate ways. How hard is it now for me to go back and re-update all those documents, maybe take that person off, put someone else on?
Easy, because you own it. Yeah, okay. You own it, so you can do it. Now, just be aware though. Okay, so beneficiary form, simple. You just do a change of beneficiary and you're done. The problem lies if you have certain assets titled jointly, obviously. Then it could be a problem because you both have access to it. So if one of them gets pissed off, they could clean the account out and leave the next day, and you're done. You lost the money, so it's a problem. So that would be the only caveat to that, is certain titling of assets. Not a big deal, but you need to be aware that, hey, you better be careful with that. The other thing is, if you have this person named in your legal documents as your healthcare surrogate or as your durable power, you'll need to redo those documents to change that. Because if you don't, 5 years later, you never did anything, and that person's still the one, that person is still going to be the one, no matter what.
You may not want that.
Yeah. So I want to talk about one thing. I know we're running short on time. There's something called a domestic partnership that people may have heard of, and it's equivalent to marriage. Okay, so it's almost like a marriage, but it's not. Okay, so it's an agreement of some sort that you put together, because marriage is an agreement, right? Is a contract. But this is a separate kind of an agreement called a domestic partnership. And what I want you to realize is that in Florida, it is not recognized statewide. So it's recognized by county. So certain counties may allow it, other counties may not allow it. So it's kind of screwed up. It's very inconsistent in the state of Florida. And what it does is it gives that person visitation rights for healthcare and dealing with incapacity issues, stuff like that. But what it never does, it never gives you inheritance rights. So even if you have a domestic partnership and it's recognized in Florida, you won't get an inheritance if the person passes away. You got to do that will or that trust. You won't get Social Security benefits or anything like that either. So it just does a little bit. It gives them a little step up if they didn't do any legal documents, and that they'll be able to deal with healthcare decision making, basically, is really what it comes down to. But it's only in a couple counties. It's not my county may say we don't recognize it. Next county over may say they do in Florida.
Man, that makes it a whole lot more complicated.
Yeah, it's just welcome to the world. It's screwed up.
Yeah. Right. So, Andy, like we said, we're running short on time, but one last question for you. Someone has been listening to us today and they realize, oh no, I'm living with a person, I'm not married to them, and I'm completely unprotected. What do I do? What's your answer to that question?
It's an easy answer. Call up an estate planning attorney and make a meeting and get together with them, but also get together with your partner in the meeting so that everyone's on the same page. The number one key to all this stuff is communication. As long as both you and your partner are on the same page and you can agree to things, then you meet with an estate attorney and then let them draft up what needs to happen. But if you don't do that, and again, I've always told you this, John, in prior episodes, the number one problem with people is procrastination. They always think, I'll take care of it tomorrow. Remember, tomorrow may not ever happen to you. I give the example of me, 8-9 years ago, having a massive heart attack at 48 years old. I shouldn't have survived, but I did. I may not have had that tomorrow. Yeah. So if you're living with someone and you are worried about this kind of stuff, you need to schedule a meeting with a proper estate planning attorney that knows what the hell they're doing.
Yeah, absolutely. And to our listeners, if you're interested in his story, I encourage you to go back to our first episode where he tells it in full. Totally caught me off guard. I was surprised. Great story. And you can see exactly where he's coming from. So Andy, hey, again, thanks so much for coming on. I love the fact that you're willing to give of your expertise and just help educate people.
Thanks, John. Appreciate it. Have a great rest of the weekend.
Absolutely. And to our listeners, thanks for tuning in to If You Don't Plan, You're Stupid. If you're in that committed relationship, but you're not legally married, you need to take planning seriously. So visit rosenberglawfirm.net to start building a plan that puts your partner first. Of course, don't forget to subscribe, leave a review. Again, go back and check out some of the old episodes. Share it with someone who might need it, and we'll see you next time.
Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.